lady, it seems that some people are being favored over us, and in this matter, it is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024. And we thought that we would be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November. So at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that regardless side has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners, and others will just be thrown under the bus and into the darkness. Thank you.
My lord, if I may respond, my lord.
Sorry, just a minute. Can you just clarify your application? You say is dated the 8th of October?
8th of October, 2024.
The substance of the application?
It's petition E541 of 2024. We were seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Fiona, maybe with your kind permission.
Let me clarify. Is that the matter in which you are appearing with Dr. Eboso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Boso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are petitioners in cohort number 1. And we directed everybody to get into the CTS system, and whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in these proceedings. You have been enjoined. You are a party, and that is why we allowed Dr. Boso to address the court, even yourself to address. So you are a party. You are a party. That one I can assure you.
My lord, we were not entitled to the right of enjoinder, and we had points that we wanted to defend against the respondent side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week, after the swearing in would have been gone through, and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my lord.
So I think we may not wish to respond on whether you are discriminated or not, but we are so sure you are not discriminated, because there are proper directions in respect of every cohort and every matter before us. Kindly take time to go through the CTS.
Yes. My lord,
thank you. This court had made directions on this issue. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications. We are finished with this side.
You have not spoken on behalf of the second petitioner.
My lord, that we would like an opportunity to respond to both applications that are being brought today.
Maybe I can say one thing, just on behalf of the second petitioner. My name is Kimotho Teresia Wanjiru Makazi. Yes, there's Kimotho in company advocates Kegoya. We welcome the ruling. However, there are some bits that we feel aggrieved and we wish to appeal. And therefore, as we do the notice of appeal, we are praying that we are in support of the issue for injunction, no the issue for stay, which the court may say it's a negative order, but we are saying pending the time we do the appeal, at least the status quo be maintained. And also we wish to say that there was an issue that the Court of Appeal today, application for stay, that is not true. We were told to serve, parties were not all served, and that's the reason why we were given another date. So therefore we are in support of these two applications that have been made today.
Thank you. Let's Wanjiru also. Mr. Dr. Bosso, please sit down. Please sit down.
My lord, this
Please,
court,
please sit down. Please sit down.
will I be given a chance to speak?
Please sit down. Ms. Wanjiru, proceed.
Yes, my lord. As a young woman, I'm under 35, my lord. I'm actually 35. I'm a youth and I have a disability. And we're the only ones, I think, on the platform that check that we have a disability, my lords and my lady. Our constitution, Article 1.1, has to count for something. Because it was intended for us to come to court directly.
Please respond to the application. Support, make the application.
Yes, my lord, I'm in support of the
Yes.
application. Mr. Obliged.
My lord, finally. My lord, in response to the two applications, or yours also an application. Yes, my lord, in response to the application by my learned friend, Mr. Ochiel, future senior counsel, and my learned friend, Mr. Ndegwanjiro, I wish to set as follows, my lord. My lord, number one, the Matthew paper order sought by my learned friend fall on the basis of the following principles. Number one, my lord, there is already an appeal that has been filed in the Court of Appeal, and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my lord, a party can only apply for stay in the Court of Appeal. That's point number one. My lord, point number two, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My lord, that matter therefore